It's wonderful to see so many of you here for our commercial seminar. We've chosen for this seminar the headline topic of share sale disputes, as many of us have noticed a substantial increase in their frequency in the last few years. And we've received many suggestions from professional clients, you, that a seminar addressing some of the issues which arise in such disputes would be useful. Lord Sumption observed in Rock Advertising that party autonomy operates up to the point when the contract is made, but thereafter only to the extent that the contract allows. These words set the scene for the issue of the court's approach to contract terms, which are intended to set out the agreed basis on which the parties have contracted. Lord Sumption made his observation in the context of whether a contractual term prescribing that an agreement might not be amended save in writing signed on behalf of the parties, a so-called no oral modification clause, was legally effective. The Supreme Court in Rock ruled that the law should and does give effect to such a contractual term, just like the law gives effect to those terms called entire agreement clauses. One practical consequence of enforcing such terms is to preclude a contracting party from advancing a case which is contrary to what the term provides. For example, that there has been an oral variation, or that there is some other agreement relating to the subject matter of the contract. In the Regione Piemonte case, Lord Justice Christopher Clark held that the juridical basis for giving effect to the entire agreement clause in the parties' ISDA master agreement, in that case, was a Springwell estoppel. The reference to a Springwell estoppel is, of course, a reference to the so-called doctrine of contractual estoppel, articulated in the judgment of Lord Justice Akins in the Springwell navigation case. The issue in that case was whether contractual statements by Springwell of non-reliance on representations or warranties with respect to the advisability of a particular financial instrument, and in any event, whether other contractual statements by Springwell that no such representations or warranties had been made, meant that Springwell was contractually estopped from contending that there were any actionable representations that had been made to it on which it could found a claim under the Misrepresentation Act or for negligent misstatement. Lord Justice Akins held that if A and B enter into a contract, then unless there's some principle of law or statute to the contrary, they're entitled to agree what they like. And he added that there's no legal principle that states that parties cannot agree to assume that a certain state of affairs is the case at the time the contract is concluded, or has been so in the past, even if that isn't the case, so that the contract is made upon the basis that the present or past facts are as stated and agreed by the parties. These dicta of Lord Justice Akins, together with obiter dicta of Lord Justice Moore-Bick in the earlier influential case of P.K. Intermark, have somewhat dismissively been called by Professor Gerard McNeill KC in his chapter on exemption clauses and disclaimers in the 2017 book Defences in Contract, T-shirt philosophy. That is an eye-catching phrase, but Professor McNeill's comments have not subsequently found favour with the judges. So in 2018, Lord Justice Lewison, in the First Tower Trustees case, held that it is now firmly established at this level in the judicial hierarchy that parties can bind themselves by contract to accept a particular state of affairs, even if they know that state of affairs to be untrue. This is a particular form of estoppel, which has been given the label contractual estoppel. Unlike most forms of estoppel, it requires no proof of reliance other than entry into the contract itself. Thus, as a matter of contract, parties can bind themselves at common law to a fictional state of affairs in which no representations have been made, or if made, haven't been relied on. In the same case, Lord Justice Leggett, as he then was, said that he could see no reason in principle why it shouldn't be possible for parties to an agreement to give up any right to assert that they were induced to enter into it by misrepresentation, provided that they make their intention clear. These dicta are consistent also with what Lord Toulson said when giving the opinion of the board in the Privy Council case of Primeside, a board constituted also by Lords Newburgh, Wilson, Reed and Carnworth. He said that giving effect to contractual estoppels accorded with the principle of party autonomy. He added that parties are ordinarily free to contract on whatever terms they choose, and the court's role is to enforce them. There are exceptions and qualifications, but these two are part of the general law of contract. Contractual estoppels are subject to the same limits as other contractual provisions, but there is nothing inherently contrary to public policy in parties agreeing to contract on the basis that certain facts are to be treated as established for the purpose of the transaction, although they know the facts to be otherwise. The reference to the exceptions and qualifications, which are part of the general law of contract, illustrate, for example, that a contractual estoppel has no effect where the contract in which the purported estoppel is contained may be void for fraud. As Professor Jo Braithwaite memorably put it in her seminal paper Springwell Watch, New Insights into the Nature of Contractual Estoppel, fraud is to contractual estoppel as kryptonite is to Superman, namely the single factor which always leads to defeat. But don't think from that quote that contractual estoppel is always as invincible as Superman. We'll come to that in a moment. In the later case of Chen and Ng, the Privy Council, in a board consisting of Lords Newburger, Mance, Clark, Sumption and Hodge, reaffirmed what had been said about contractual estoppel in prime side, and the important point was made that the description contractual or conventional estoppel was a confusing misnomer. The real analysis was that parties should simply be regarded as having committed themselves by a contractual term to a particular proposition. This is what Lord Justice Briggs, as he then was, had concluded in Wood and Capital Bridging Finance. The essence of contractual estoppel, as it is now understood, is that it has contractual force. Most significantly, however, is the fact that in February 2021, in the judgment of Lord Leggatt, with whom the other 5 justices agreed, Lord Kitchen, of course, being unwell, the UK Supreme Court, in the context of making a point about statutory prohibition against contracting out, took the opportunity to confirm the existence of the doctrine. The case law to which Lord Leggatt referred was the First Tower case, of course, including his own judgment. But there are, as I've mentioned, some caveats and qualifications. First, it is essential to construe the provision said to found the contractual estoppel. Does it really have the effect which the party relying on it asserts? The court will want to be satisfied that the intention of the parties is clearly and unambiguously expressed as claimed by the party asserting the contractual estoppel. Secondly, in a case where party X alleges that it was induced to enter into the contract by misrepresentation by party Z, is the meaning of the term on which Z relies to undermine X's claim in substance an attempt by Z to exclude or restrict its liability arising under Section 2.1 of the Misrepresentation Act 1967? If so, then it's likely, irrespective of the ingenuity of the drafter, that the term will be ineffective unless it satisfies the requirement of reasonableness under UCTA. And relevant factors in that regard will include whether both parties had legal advisors, whether there was a substantial imbalance of bargaining power, whether the term in question was open to negotiation, whether reliance was permitted on statements made in other identified documents. Thirdly, the courts will treat contractual statements differently in the classic private law cases, such as Springwell, from cases where statute is involved or where there is a clearly recognized legal relationship, such as a fiduciary relationship. So in the Uber case, Lord Leggatt made clear that terms which sought to bind parties to accept a particular state of affairs, even if they knew that state of affairs to be untrue, would, however, be ineffective because their object was to preclude a driver from claiming rights conferred on workers by the applicable legislation. So too, the legal reality, as Lady Justice Gloucester put it in the NRAM case, will trump the state of affairs described in any contract. Fourthly, in relation to the issue of a party's alleged lack of capacity, the better view appears to be that where a contract is ultra vires and void, it follows that any promise, representation, or assumption contained in it to the contrary is also void. Now, this is not my advice to you as to how to avoid the mayor's new ULEZ charging, but it's a car, standard 1947, familiar to some, I assume, which Mrs. Lowe got on hire purchase from Lombank Limited. And when she was deciding whether to get the car, the salesman said that it was a nice little runner. But of course, in reality, it was completely unroadworthy and a danger to all and sundry. She issued a damages claim. The hire purchase company sought to defend her damages claim by relying on various statements she had made in the HP agreement and a delivery receipt. Now is not the time to delve into the weeds of that case. Suffice it to note that the Court of Appeal gave Lombank Limited short shrift, holding that they were impermissibly trying to evade the provisions of the 1938 Hire Purchase Act. And indeed, although contractual estoppel wasn't argued, that's why any such argument, if it had been, would have failed. But in the course of his judgment, Mr. Justice Diplock, on day release from the commercial court, as Mrs. Justice Cockrell said in her article on contractual estoppel in the 2022 Journal of Business Law, held obiter that a statement as to past facts known by both parties to be untrue can't be converted into a contractual obligation. That dictum has sought to be relied on by parties resisting a contractual estoppel argument, and those suggesting that the doctrine is constructed with the equivalent of reinforced autoclaved aerated concrete. However, Mr. Justice Diplock's dicta have not been followed and have been ignored in subsequent cases. And indeed, in First Tower, Lord Justice Leggett, as he then was, didn't even refer to the relevant words in the quote he gave. But in terms of current judicial attitude, Lowe and Lombank has, to quote Lord Denning, been put on one side and marked not to be looked at again. So the reality is that the doctrine of contractual estoppel, and in its present form, is here to stay. That's it from me. Can I now hand over to Adam Solomon KC, who is going to speak about notification of claims in relation to share sale agreements.
Thank you, Charles. We find ourselves in a situation in which purchasers wish to bring a claim against vendors under the warranties in a share purchase agreement. Assuming that you've checked that the law is the law of England under the contract and the English courts have jurisdiction, and that the relevant breach falls under the warranties and isn't otherwise excluded, the next step is notification to the vendor. Almost all SPAs have notification clauses obliging the purchaser to make clear to the vendor that a specific claim is being made under a specific warranty. And the consequences of non-compliance with the notification provision are severe, as Richard Millett QC held in the Tiocco case, which I've got up there, and which was upheld in the Court of Appeal, and all the references to all the cases are on the final slide. A notification provision is intended as a gateway to liability. So as a gateway, it's a necessary prerequisite to bringing a claim. And as the judge emphasises, the burden of proof is on the party relying on the notification provision and wishing to bring a claim. With non-compliance, the purchaser's claim will fail. And that's even if at trial, the court has held that there was a breach of warranty. But compliance with notification clauses is often considered as a preliminary matter, pursuant perhaps to a summary judgment application or for strikeout. And the courts regularly strike out cases where there's been a failure to comply with notification provisions. And I've referred to a couple of cases on this slide where courts have done so. The Irani case, not simply because like all barristers, I only want to refer to cases in which I won. But because it is a recent example of a case in which the court struck out a claim based on breaches of warranty for a failure to comply with notification. And in Drax, a very recent High Court case, which was a buyer's warranty claim, struck out because the claim set out in the notification letter was based on the wrong formulation of quantum. And so even something as apparently minor as that can lead to the claim being struck out. The purpose of the notification clause is to make clear in sufficiently formal terms that a claim is being made against the vendor. It provides the vendor with certainty, either knowing that it won't face any claims because a notification provision has a time limit. So if it's not notified within that period, you know you won't face a claim, or the basis upon which a claim will be brought, so to enable a specific financial provision to be made. And as was held by Mr. Justice Cook in the laminates case, notification clauses are usually inserted for a purpose to give a party notified certainty, and failure to observe cannot be dismissed as a technicality. And the purpose of the notification clause is not served, as was held in the Ipsos and Dentsu case, if the notice isn't informative enough or isn't clear enough. And the purpose there are a number of purposes for such clauses. First, to enable the vendor to make relevant inquiries. Secondly, to enable investigation into the merits of a claim. Thirdly, to enable the vendor to participate and perhaps attempt to influence the outcome of a tax investigation. And fourthly, to take into account the nature and scope of the claim in the future business dealings, perhaps by reserving amount in accounts. And SPAs often have a provision whereby once a claim has been notified, there is a retained amount for the quantum under the SPA. And so you can see that the notification goes hand in hand with the ability to retain and perhaps set off under the SPA amounts paid for the business in the first place. And so it's fundamental to the working of the whole SPA. And that's why failure to comply is not a mere technicality, but is fundamental. But all cases turn on the terms of the specific notification clause. However, many of these clauses are similar. They're often boilerplate clauses. And I want to consider some aspects of notification clauses that commonly arise in these cases. Firstly, construction and specificity. Normal rules of construction apply pursuant to contractual construction techniques, but those must be seen in the context of the clause which I've just talked about. In other words, to give specific commercial certainty. And they almost always oblige notification of the particulars of the allegation. So as was held in the Senate electrical case, certainty is only achieved when the vendor is left in no reasonable doubt, not only that a claim may be brought, but of the particulars of the ground upon which the claim is to be based. And in the Irani case, the court considered the various commercial purposes of such clauses. And the court held that first, they're not served if the clause is uninformative or unclear, but on the contrary, they need to be precise and particularized. Secondly, a clause is construed by answering the question as to how it would be understood by a reasonable recipient with the knowledge of the context in which it was sent. But that context is the reason why the clause is important. And Thirdly, the notice must specify that a claim is actually being made rather than indicating the possibility that a claim may be made. And that was the reason why the purported notification letters failed in cases like laminates and in Irani. And fourthly, the burden is on the party seeking to bring a claim to demonstrate that it's complied with the notification provisions. That's important because this point often arises in a defence to a claim or in a summary judgment application, but the burden remains on the claimant, who is the respondent to the summary judgment application. And lastly, and perhaps counterintuitively, notification will normally require specifying matters already known to the vendors. Now, that depends on the strict wording of the clause and all the circumstances of the case. But if you're in any doubt, include matters even if they're known to the vendors, and authority for that is the Senate case and Dodica and United Luck. As to timing, these clauses almost always have time specifications, both as an outside limitation and as to promptitude. And these time periods are strict. So in Irani, the claimants under the relevant clause were not liable for any warranty claim unless notice was given within 16 months following completion. The SPA was dated the 1st of November 2018, and notification letters were dated the 2nd of March 2020, being 16 months after completion, but not within 16 months after completion. So 1st of March letter would be fine, but the actual letters were sent on the 2nd of March, and they were outside the limitation. And that was important, not simply because that meant the notification letters failed, but as the judge held, they were a last-minute tactic designed to avoid having to pay the claimant's money in the retention account. And that tactical approach, last-minute tactical approach, impacted adversely on the judge's attitude to the claimant's other points. So the claimant asked for the retained $2 million to remain in court rather than being paid out to my clients because there was an outstanding amended fraud counterclaim. But the judge didn't accede to that proposal. Fraud there wasn't the kryptonite that Charles has referred to. And there are often additional provisions for promptitude, and those are in addition to the final cutoff date. So you must notify by X date, but it promptly in any event. And the promptitude obligation applies notwithstanding there's a final cutoff date. So you might be out of time before the cutoff date. Multiple warrantors. Zio Group is a chilling case in which there were a number of warrantors and the notification letters were sent to a number of the vendors, but not to one. And in that case, the judge held that the correct construction of the notification clause obliged service on every single one of the vendors in order for any of them to be liable. And that meant that the claim was struck out. And it's a cautionary tale for claimants who've got to serve on all the warrantors under an SPA. So tell your client to read the clause carefully and comply precisely with it. However, although claims under contractual warranties are subject to the strictures of complying with the notification provisions, a claim in fraud, even under the warranties, is almost always excluded. So in Irani, although the contractual warranty claims were struck out and my clients obtained summary judgments for the retained amounts under the SPA, the defendants were allowed to amend to plead a new claim in fraud, which succeeded at trial. So for that reason, I'm not going to talk about that aspect of the case. Those are the cases I referred to, and I'm now in the happy position to hand over to David Lascelles, who was also in Irani, who will be talking about money.
Thank you, Adam. Good evening, everyone. I'm going to talk this evening about money, 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 which, as you may anticipate, is going to be a little talk on quantum, but also a nod there to ABBA, whose avatars I'm looking forward to going to see in a couple of weeks' time. The particular topic within quantum that I'd like to talk about is the impermissible use of hindsight, when you can and when you can't take into account matters that have happened after the SPA to value the company for the purpose of quantum. So a quick refresher on the measure of loss in an SPA claim. And as Adam has mentioned, this can be particularly important to get right because notification claims quite often fail due to the failure to get this spot on. And really, there's two elements that are important here. First of all, the court needs to work out what the value of the company is on the basis that the warranties are true. Often taken as the purchase price, though not invariably. That's the first element of the calculation. Then the court needs to assess what's actually happened, to what extent are the warranties in breach, and it calculates what the price of the company would be based upon that warranty false position. So warranty true as against warranty false. And for both of these, what the court is doing is it's looking with expert assistance to carry out an assessment. What would have happened if a hypothetical buyer and seller had come together, arm's length terms, and looked to agree a price on one basis warranty true, on one basis warranty false? And it contrasts the two, and it's that impairment to the share price which is recoverable on a share sale dispute. Now, the usual contractual principle applies, so the court is assessing damages at the date of breach, which in a share sale dispute will almost always be the date the warranties are given. The question arises, as I say, to what extent can the court look at matters after that date? And to take into account the possible options here, I think it's important to recognise the fact that share price will always be based in part upon contingencies. Will a particular contract materialise? Will an existing contract fall to be terminated? Will a claim be made against the company? So inevitably, these sort of features are going to be part of the share price. And what often happens in these cases is that the outcome is uncertain at the date of the sale. But by the time a few years later you get to trial, everybody knows what's in fact happened, whether the contract has materialised, the claim been made, and so on. And so the question for the court is, to what extent is it entitled to look at what's happened after the sale to work out the hypothetical warranty false price? The reason this comes up time and again is this is what sellers do. The sellers say, yes, if we're found in breach, it might be the case that there was a claim we didn't tell you about or a contract that was looking like it was about to be terminated. But hey, everything's worked out okay in the end. Don't reduce the warranty false purchase price on this basis. And so it's nearly always been prayed and aid by sellers seeking to avoid the usual outcome of them having failed to provide proper disclosure. Perhaps unsurprisingly then, the general approach of the court at first instance has been to say, no, you can't take into account what's happened after the sale for the purpose of reducing the amount of liability. But we haven't until recently had an appellate authority on the matter. That's all changed last year with the case of MDW and Norville. Let me tell you a little bit about the case. So MDW involved the sale of a waste disposal business, so not a very glamorous industry. And indeed, what had been happening wasn't very glamorous either, because what the company had been doing pre-sale was dumping more waste than it had license to in a public sewer. So it had found a sewerage inspection chamber, which was known internally in the company as the magic hole, and it had just stuck a pipe in, and any waste that it didn't have permission to dump, it had just channeled into this hole. In doing so, it had avoided both its license terms, and it had also avoided the cost of having to go out and pay somebody else to dispose of this material. Buyers discovered this after the sale, no doubt were very cross about the matter, because one of the big issues it gave rise to was a potential claim by the Environment Agency. We've of course seen a lot in the press over recent times about companies dumping excess sewage in the public waterways, and this was likely to be very toxic to the company if it was discovered. Massive reputational risk here, and so at the date of sale, this would have significantly reduced the purchase price. But as things turned out, no claim was made by the Environment Agency. The company flourished and started to dump all its dump in the right places and pay others to take excess dump after the sale. So the sellers argued in the usual way, there shouldn't be any reduction here. There's no reputational harm. In fact, to award the buyer in this situation compensation based on this reputational harm would be to overcompensate them. The company's doing great guns. The Court of Appeal, like the trial judge, did not agree with that argument. Like the previous first instance decisions, it held it's illegitimate to look at post-sale matters for the purpose of working out the sale price as at the date of the sale. Quantum couldn't be reduced on the basis that the contingency hadn't arisen. And it said that it wouldn't be fair to do so because ultimately, at the date of sale, what you have is a risk allocation going on. You pass the company over to the buyer, and from that date, if it flourishes, that's for the buyer's account. If it fails, that's for the buyer's account, and the buyer is left with their breach of warranties claims. And it wouldn't be fair to allow the seller to come along afterwards and effectively almost change the date of assessment by pointing to matters that had happened afterwards. Now, no doubt, after some difficult tactical consideration, the buyers in MDW themselves thought that they would also look to rely upon some post-sale matters. What they said was this: there's no records of what went into the magic hole, and so we don't know the extent to which the company had pre-sale actually been overdumping the waste. But what we do know is how much waste had to be sent off to an external operator post-sale. And they said we should be able to look at the records of what happened after the sale, how much excess waste there was, to work out from a quantum perspective how much excess waste there was pre-sale. And the Court of Appeal said, yes, actually, you can do that. It said you can look at post-sale matters in order to shine light on events that had taken place pre-sale. So a very buyer-friendly decision there. Now, there have been a number of first instance decisions which have considered MDW and Norville. The one I'd like to talk about is the case of Irani and Cordic, which is a case that Adam has mentioned, where the ordinary share sale warranty claims were all struck out due to failure to notify, but the fraudulent breach of warranty claims unfortunately scraped through that application as fraud trumps the notification clause, and so proceeded to trial. Cordic was a case about a taxi app business. So it made an app much like Uber that allowed taxi drivers, taxi companies to deal with route management and also allowed users to select their location, select their drop-off location. And for those purposes, it used the Royal Mail Address Database, which is the gold standard of address databases in this country. The gold standard costs a golden amount. It was £2 million per year for the full licenses for all the taxi drivers and the taxi companies. However, the sellers devised a way of buying a £200 a year license and taking all the address data from the relevant product and then supplying it to every driver and every taxi company, many thousands of drivers who used the app. And perhaps surprisingly, that was found to amount to a breach of the relevant license terms and indeed a breach of the warranties. And so the real battle in many ways in Irani was over quantum. Now, there hadn't been any claim by the Royal Mail, and so it's common ground there could be no reduction on that basis, CMDW. But what the sellers argued in Irani was you can look at what's happened after the sale. In particular, what happened after the sale was the purchasers came in and they said, we're not going to spend £2 million on Royal Mail. Instead, what we're going to do is to use Bing Maps instead. I don't know if you've ever used Bing Maps, but anyway, Bing Maps is £100,000 per annum rather than £2 million per annum. And the result was the sellers said that Bing was going to reduce the purchase price by £600,000. So that was the limit of their liability here. The buyers, in the usual way, their accountant reached over to his alchemist's dust and sprinkled it over the claim, and that £2 million per annum license amount became £32 million worth of losses. What did the judge decide? Well, the judge sided with the sellers, the judge says you can look at what the thinking is, what the actions are of the buyer, not just before the sale, but after the sale. Ultimately, what we're asking here is, what would a hypothetical reasonable buyer and seller agree about the purchase price? And for that purpose, the buyer themselves, the actual buyer, we can look at what they did, and we can say that informs how a hypothetical buyer would have acted pre-sale if they'd been told about these issues. A hypothetical buyer who had been told about the issues and had been told about the cost of the relevant services would also have decided to go with Bing. And therefore, the judge said that he would order damages on this aspect of only 600,000, not the 32 million sought. To go back to ABBA and to paraphrase slightly, the winner didn't take it all. For the future, I think really there's some fertile ground for litigation here, looking at what's happened post-sale, some inventive arguments that the sellers will likely be able to run in many cases about what has happened post-sale as the buyer has sought to rectify the position, and a real dispute as to what counts as admissible and inadmissible after MDW and Irani. But certainly there's some good arguments that are likely to be ran here by many sellers. What's going to be essential is going to be disclosure, so having a hook in the pleadings and then a good pressure put on the buyer when it comes to disclosure. That was one of the really key things in Irani, ensuring that there was disclosure post-transaction matters. Thank you very much. I'm going to pass over to Charlotte Davies, who's going to speak about deceit.
Thank you, David. Good evening, everyone. In the next section of the seminar, I'm going to be looking at the position of an innocent seller in respect of claims for deceit. And I've been sitting here racking my brains for some clever ABBA link to continue the theme through, but my ABBA knowledge is nowhere near good enough, so I've failed on that one, I'm afraid. But we're going to be considering the following scenario. So there's a potential share sale. A particular individual is responsible for negotiating the sale on behalf of the vendor. That individual makes false representations to induce the sale, and the buyers are in fact induced by those representations to complete the sale. Now, obviously, a claim in deceit will lie against the individual who made those false representations. But what about the position of the vendor who they were acting for, who didn't make the representations, didn't even know about them? Are they also liable for the deceit? Well, the answer is that they might be. And over the next 10 minutes, we'll consider the applicable test and some of the practical points to be aware of if you're faced with this scenario. So you recall in our scenario, the vendor hasn't made the false representations to the buyer, and so they're not directly liable for the deceit. But there are two different routes by which they might become liable for those false representations. So firstly, if they subsequently manifestly approve or adopt those representations, and that's communicated to the claimant, then the innocent vendor loses their innocence and becomes liable as a primary tortfeasor. And you'll see the case reference on the slide. Secondly, and what we're going to be focusing on for the next few minutes, is that they may become liable as a principal for the acts of the individual representor as their agent. So how do you show that the individual who was negotiating the sale was in fact acting as that vendor's agent? Well, the usual agency principles apply. So agency might arise either at the time by the conferral of authority by the vendor on the individual to act as their agent, or retrospectively by later ratification by the vendor of acts done earlier. And you'll find an example of subsequent approval in the context of sale negotiations in the case of Brees and Woolley, as referred to on the slide, which we'll come back to a little later on. Now, you might be lucky and have a really neat case where there's a full, clear paper trail which shows the conferral of authority to negotiate. But perhaps more commonly, as we'll all know, you'll be faced with a murkier picture where any agency argument is based on oral express conferral, where there's a dispute about the words which have been used or the meaning of those words, or an agency argument which is based on an implied conferral of authority. The good news, if you're acting for buyers, is that you don't have to have direct evidence that authority has been conferred by the principal. This can, in fact, be inferred from wider circumstantial evidence. So in the scenario we set out at the beginning, where an individual has taken the lead in negotiating the sale, Whilst it's of course possible that there's going to be an argument about whether agency arose at all or whether the individual was essentially acting on their own, the focus of any dispute is often going to be on the scope of the authority that that individual had and whether they exceeded the scope with their fraudulent acts. That brings us on to the test for establishing whether a principal is liable for his agent's deceit. And the test was set out by the House of Lords in the Ocean Frost case, as followed in the last few years by the Court of Appeal in the Hockley Mint and Ramsden case. So a principal is vicariously liable for the deceit of an agent if, but only if, the following three elements are satisfied. There's been a holding out or representation by the principal to the claimant, which was intended to be, and in fact was acted upon by the claimant, that the agent had the authority to do what he or she did, which includes acts falling within the usual scope of the agent's ostensible authority. And you can see, looking at this test, the focus is on the authority of the agent as it appears to the claimant, deceit being a reliance-based tort, rather than on interactions between the principal and the agent. In Hockley Mint, the Court of Appeal rejected the application of any broader test for vicarious liability to a principal's liability for his agent's deceit. In that case, the judge at first instance had been through various authorities on vicarious liability in a range of different contexts and had derived from those authorities a two-stage test. So stage one, the judge had said, was whether it was fair for the principal to be liable for the agent's deceit. And stage two was whether there was a sufficiently close link between the false representations and the acts which the agent was authorised to do. That approach was wrong, the Court of Appeal said, because the cases which the judge had derived this test from didn't involve a reliance-based tort such as deceit and weren't about the authority of an agent as a result of a holding out by a principal, but rather concerned acts in the usual course of employment or business. And the effect of this is that a claimant can't rely on broader principles of vicarious liability to make a principal liable for deceit by his agent where the relevant representations were beyond the agent's authority. So in the case of deceit, vicarious liability is more limited. The relevant acts, the representations, must have been within the scope of that authority for the principal to be liable. The Ocean Frost test does beg the question then, what conduct will amount to a representation by a principal that the agent had authority to do what they did? Now, a representation, of course, doesn't have to be through specific words or specific conduct. It can be implied by acts of a quite general nature. And we can look to the case law for examples of what a representation of authority to negotiate a sale might look like in practice. Going back to the Hockley Mint case, the Court of Appeal there considered various factors as being capable of establishing an agent's ostensible authority to conduct negotiations. So firstly, the principal had given the individual contractual documentation and the right to use their headed note paper in the course of negotiations. Secondly, the principal had insisted on the individual using a pseudonym in the course of those negotiations. And finally, they'd given them an email address within the principal's company, which the principal was also monitoring. And the court said that those matters emanated from or with the authority of the principal and were intended to lead the claimant in that case to believe that the individual negotiating had authority to do so and to commit to the principal's company. So those factors taken together could be enough to give rise to ostensible authority to negotiate. And to look at another example, in the case of Brees, which I mentioned earlier, an instruction to an individual to take the matter up further with a view to completing the transaction was held to amount to a conferral of authority to do what the agent thought was necessary to achieve a sale. So from these examples, it seems that the court takes a fairly broad approach to finding that there has been a representation by the principal that the agent had authority to negotiate. It's not without limits. If a claimant knows that the agent didn't have any authority for certain acts, as was discussed in the Ocean Frost case, there's no liability on the principal. And the more unusual and unexpected an agent's actions, the stronger the argument may be that they the claimant or buyer can't have relied upon them as being authorised by the principal. Even if the buyer, though, can show that the individual had authority to negotiate on behalf of the principal, is there a further hurdle that they have to clear of showing that the agent had authority to make the false representations? This point was considered fairly recently in the case of Ivy Technology and Martin and Bell. Adam will be pleased that this is another one of his cases that I'm referring to. And David Lascelles also appeared in that case. Ivy was a case very similar to the scenario which we've been considering, where the buyer alleged deceit against the individual who'd negotiated a sale and also claimed deceit against another vendor on the basis that the individual had been acting with his authority. The purported principal argued that he couldn't be liable for the individual's false representations made during negotiations unless he had given that individual authority to act fraudulently. And it's easy to see the logic in this argument. You might say, why should the principal be liable for the rogue acts of his agent, which the principal hasn't authorised? But this argument was rejected. Essentially, the judge found that what matters is the broader nature of the acts for which the agent has authority and not the manner in which they are performed. So in that case, the agent had authority to conduct the negotiations on the principal's behalf, and because the false representations were made in the conduct of those negotiations, they fell within the scope of that authority. And in reaching this conclusion, the judge referred to various authorities, including the case of Barwick and English Joint Stock Bank, which found that a principal is liable for an agent's manner of performance of an authorised class of acts. And after all, it was pointed out in Ivy, it wouldn't be just to allow a principal to be able to take the benefit of an agent's fraud, but without bearing any risk of liability for it. What's more, in practical terms, it would be unworkable for a principal to be liable only where they'd specifically authorised the particular acts which were being relied upon. As to whether any given representation falls within an agent's authority in a particular case, there's no easy one-size-fits-all test. It depends on the context and the factual matrix. As it was, I think, rather poetically put by Lord Justice Stevenson in the case of Kooragang Investments, the usual shades into the unusual at different points in different cases. In that case, the agent's actions did fall outside their authority, and they were said to be so clearly and extravagantly unusual for a man in his position that it should not only have put the plaintiffs on inquiry, but it fell outside his authority. So it would seem that it's a pretty high bar to show that acts were outside the agent's authority for the purposes we're considering. So finally, to briefly draw the threads together, while the test for a principal's liability for their agent's deceit is narrower than other forms of vicarious liability, it will still be satisfied in many cases to fix a principal with liability for deceit. Thank you. On that note, I'll hand over to Nick Goodfellow for the final talk of this evening's seminar.
Thank you, Charlotte. Good evening, everyone. My talk considers the following scenario. The buyer of a company alleges two things. First, that the acquired company's success was sustained by unlawful practices. And then second, the sellers, of whom there were several, deliberately misrepresented the position when they assured the buyer that the business was being carried out lawfully. Now, the buyer wants its money back. And one might colloquially ask, is it a case of buyer's remorse, or has the wool been pulled over their eyes? And I'm going to focus particularly on the question of whether the claimant has properly pleaded a case that the defendants had knowledge that the representation made was false or were reckless as to falsity, being one of the essential ingredients in a deceit claim. Now, of course, when alleging fraud, several well-known strictures apply. In particular, first, the pleader must be satisfied that there is credible material to support the contentions made. Secondly, if the claim is merely based on an inference as to dishonesty, the facts on the basis of which the inference is alleged must be fully set out. Now, in my view, this is a particularly exacting requirement. What it means is that if a claimant is on the receiving end of a strikeout application, it's not open to it at that point to try and shore up its position by pointing to other primary facts in witness evidence to support its claim in deceit. Instead, it needs to set all of that primary material out in the pleading itself. Now, in the scenario we're considering, there's numerous reasons why a claimant that brings a claim of deceit may seek to cast the net widely when deciding which parties, sellers to add as defendants. They may believe that a wide pool of defendants will increase the chances that material will emerge in disclosure to bolster the claim that they're bringing against some or all of the other defendants, and particularly when the claim in deceit is also mirrored by a conspiracy claim. There may be reasons based on the asset positions of the parties which make it attractive to plead the claim as broadly as possible. And the claimant may also be influenced by a desire to avoid having to bear the costs of amending later down the line. Now, in my view, factors such as these increase the chances in deceit claims that a claimant might well overreach itself. The courts have adopted a particularly stringent approach to weighing up when a pleaded allegation of dishonesty should be allowed to proceed to trial in view of the seriousness of the allegation. It's not good enough to allege equivocally that a defendant knew or ought to have known the truth. The claimant must allege in terms that the defendant did know or was reckless to the truth, and where that is based on inference, set out the primary facts on which it relies to draw the inference. And at the strikeout stage, the court will assume the pleaded fact to be true. Crucially, and this is the second point on the slide, and this really goes to the heart of the legal test on a strikeout application, where the pleading is based on inference, the court must be satisfied that the facts pleaded make the inference of dishonesty more likely than an inference of innocence or negligence. And authority for that proposition comes from the judgment of Mr. Justice Flo, as he then was in the Bank of Moscow and Keckman case. Also see Lord Millet in Three Rivers. I think it's worth taking a step back here. Right? In my view, this is a high bar for a claimant to overcome, because if all the pleaded facts show is that the inference of dishonesty is reasonably arguable, but it falls short of being more likely than not applying a 50% threshold, then the claim should not be allowed to proceed to trial. Now, I think that what this means is there'll be claims that will fall into what I might term the grey zone, where the pleader considers that there's reasonably credible material to support an inference of dishonesty and pleads that contention. However, those facts don't have overcome the Keckman threshold, and the claim falls to be struck out as pleaded. Now, for an illustration of a case similar to the scenario I've referred to in the share sale context, see Jinxin and Asa Media. This is an ongoing claim in which I'm acting as junior counsel for one of the defendants, a corporate seller of shares in a media rights business. Now, in view of its ongoing status, I'll briefly summarize the outcome of the interim judgment in which the majority of the case against my client has been struck out. Now, a core allegation made in the proceedings is that the media rights business had acquired the distribution rights for inter alia Serie A, the well-known Italian football league, by adopting unlawful practices. Now, that's a matter that is disputed. The claimant, which is a company that bought a majority stake in the business for approximately $660 million US, alleges that the sellers misrepresented the position as to how the Serie A rights business had been historically conducted before the sale. Now, the case against my client on this issue was not that it had direct involvement in obtaining the Serie A rights, but in effect that it must have known what was going on because of two things. Firstly, the supposedly pervasive nature of the alleged conduct. And then secondly, the management role of my client's majority owner. It was, however, common ground that this individual was not personally involved in acquiring the Serie A rights in that management role. Now, we argued that this approach did not meet the stringent Keckman test for alleging deceit on this aspect of the claim, and the judge agreed. Now, I think what emerges from the judgment is that it is unlikely to be good enough to simply allege that because someone was in a senior role within an organisation, they must have known what was going on in a core part of that business. Now, in his judgment, the judge, Peter MacDonald-Eggers KC, sitting as a Deputy High Court judge, he helpfully draws together the core legal principles which apply on a strikeout application in paragraph 41 of his judgment in 6 sub-paras. Ultimately, in line with the Keckman judgment, the core point is that the pleaded primary facts must tilt the balance, and I emphasize those words, tilt the balance in favour of fraud. Now, the last point, which is also made, it's not on the slide, but in those sub-paras, is that the court should adopt a generous approach to the party alleging fraud. However, such generosity, and I'm quoting from the judgment, should not circumvent the requirements of pleading fraud and supportive particulars, but should be exercised, for example, where the issue, whether the plea of fraud is justified, is evenly balanced. Now, in short, in my view, only in quite rare cases will this principle come to a claimant's aid. So, taking a step back, in practice, when should you apply to strike out, and what factors should be weighed into the decision? The standout claims, I think, are those based on inference. You're asking yourself questions such as, do the pleaded facts regarding the nature of the individual's role, the scope of their reporting lines, and the email communications to which they are privy, do they tilt the balance in favour of fraud, or is an innocent or even negligent explanation more likely? Ultimately, it's a judgment call, and it may not be an easy decision. However, I think it's fair to say the benefits to be gained from a successful strikeout, even if only partial, not least in terms of ongoing costs in complex commercial litigation, mean that it'll often be a risk worth taking. And I think actually I'm quite surprised that such applications don't feature as often as you might expect. And I think that grey zone, which I referred to earlier, is somewhat wider than practitioners think. Thank you very much for listening to me.